Well, government has given Eskom permission to bypass some procurement red tape. This is to enable the state-owned company to procure coal without a competitive tender process. Head of Business Crimes and Investigations at Werksmans Attorneys, Hotz, joins us now to unpack that development. Bernard, thanks so much for your time today. So what are the provisions then for a proper procurement process to be skipped?
See, ordinarily, as we would be aware, one talks of a free, fair, open, transparent tendering process that state-owned entities are obliged to engage in. However, what we see happening here is Eskom has its own SCM policy. And in its SCM policy...
What does SCM stand for?
It's a procurement policy.
Okay.
So it's a policy that would determine how procurement happens,
okay,
what they have to do in what situations. There would be, and there is a provision, which would entitle them in certain situations to deviate from normal, if I can call them normal protocols. And we talk about a confinement. In other words, should there be an emergency situation, should it dictate that they cannot ordinarily go through the process of an open, fair, transparent tender process,
okay,
they would be entitled to bypass it. But it's not as simple as that.
Yeah.
There has
it shouldn't be, should it?
Exactly.
Yeah.
And we've seen it being abused in the past, not only by Eskom, but by various other state-owned entities. There has to be a reason. There has to be a reason that stands up to scrutiny. In fact, there's a provision in the PFMA which would entitle Treasury in certain situations, which is what's happened here. If they presented with a reason,
yeah,
they could scrutinize that reason and they could say, okay, for this particular situation, we are prepared to grant an approval, yeah, for a deviation. Okay. It's something that is an emergency. It cannot carry on in perpetuity, yeah, and it cannot be a self-created emergency.
Let's talk a little bit about that then, the self-created emergency, because many people question how Eskom got itself into a position like this in the first place, where suddenly it does not have the sufficient coal that it needs. And some go back all the way to, for example, the Tegeta contracts, and saying that, look, if we had stuck with the original plans in the past, where a company could actually get their capital injection coming from Eskom in order to build their businesses, that Eskom would have never gotten to this point in the first place. So doesn't this qualify as a self-created?
Look, hindsight is a perfect science.
Isn't it?
We've unfortunately, we've seen what's happened within Eskom. We've seen the capture. We've seen the departure from Eskom of various people. We've seen various transactions being scrutinized by our courts of law. But the one thing that we've got to be mindful of is that we have, if we can call it, a new blood within Eskom, and they have an obligation to ensure that Eskom meets its obligations to provide electricity, yeah, to the users. And there may very well arise a situation, because of what has happened in the past, that we're now facing an emergency. And one has to deal with that emergency responsibly. It has to be based upon a proper analysis of the factual scenario, okay, so that nobody can accuse people of buying in to the practices of the past, but that this is a bona fide exercise.
Just very quickly, coming back to the deviations themselves, how stringent are our procurement policies that we need to have a deviation issue? Could we not deal with that specifically?
Look, one would be aware that when you go into an open tender process, you have to follow a proper process. Yeah. And there's timing issues that come into this. And that's one of the, presumably, that's one of the emergency situations which would have to be dealt with, that one simply doesn't have the luxury of that time.
All right, we'll leave it there. Thanks for your time.
My pleasure.
Today, Head of Business Crimes and Investigations at Werksmans Attorneys, Hotz.